Mandi Gray and Emily Spanton. These two women are both from Toronto and have both laid criminal rape charges, or legally known as sexual assault charges, against men that, in both cases, steadfastly denied the charges while admitting to having consensual sex with their accuser. Both cases involved some common elements: pubs, alcohol consumption on the part of the accuser, text messages, witnesses, psychology, and the issue of consent. I won't be going into the details of the cases, but just want to focus on the overall handling of the cases and their outcomes, for the purpose of highlighting the extreme variances in how legal systems subjectively handle she said, he said claims of rape, where there can never be tangible, objective proof that a crime was or was not committed. Mandi Gray. She just won her case last week in a Toronto, Ontario courtroom. The man she accused of raping her was convicted and will be sentenced in October of 2016. The premise of the prosecution's argument was that she had been casually hanging out with him for about 2 weeks until one night, after a night of hanging out with a group of friends and coworkers at a pub, he turned into an angry, misogynist, aggressive, self-esteem destroying, abusive monster that she couldn't resist or run away from, and instead was led to his home believing that if she submitted to having sex with him, that would be better than letting him kill her. She spent the night, slept beside him in the bed, and then he woke up, put on some porn, masturbated, and tried to force her to give him oral sex. She refused, got up, and left. In the year leading up to the trial, she saw a therapist who helped her understand the event as violent and not her fault. I know. As ridiculous as all of this sounds, it is, in a nutshell, what Mandi Gray and the Crown Attorney stuck with. Read for yourself in the 180-page verdict posted in the description bar below. When a verdict is 180 pages long, the only thing it is doing is justifying a miscarriage of justice, in my view. The accused's defense argument, in a nutshell, was that while he had been battling a cold and not feeling 100%, Mandi and other friends had enticed him to meet them at the pub on the cold, wintry January night. Mandi had previously sent him a spicy text enticing him with hot sex after some drinks at the pub. He decided to go to the pub, regardless of feeling under the weather, because, hey, some sex sounded good. When he met up at the pub and sat next to her, she had groped him twice. To his surprise, he felt it was inappropriate behavior in front of the friends and coworkers. He had walked home with her arm in arm on that cold winter night, and he decided to end the brief relationship and tell her that would be their last night sleeping together, because he felt they were not compatible. She cried, they kissed, and then they had their last romp in the sack together. She left quietly the next morning. A few days later, he sent her a remorseful text apologizing for the way the breakup played out. Unbeknownst to him, she had already gone to the police to file a sexual assault charge. The premise of the judge's guilty verdict was that the accused had lied and fabricated his entire defense. The witnesses that testified in favor of the accused were irrelevant, and Mandi was raped, and there was no other way to see it other than through her eyes. He used about 100 pages just to cite case law precedents and feminist reasoning to justify believing her story over his. He cited rape myths that must be expelled from the legal system once and for all. But all of these rape myths are just that, myths. Rape myths. None of them account for the fact that women can and do lie and dramatize. Instead, the myths dodge every reason why a woman may lie as an excuse by the defendant trying to escape conviction. Well, yes, there are these things called safeguards against wrongful convictions. These so-called rape myths have done nothing other than remove the safeguards to protect the innocent accused from false accusations, wrongful prosecution, and wrongful conviction. This was a highly political verdict that outright disregards the lack of seriousness taken by the complainant, the Crown prosecutor, and feminist theory in regards to protecting the accused's security, liberty, and equal rights under the law. Which brings me to my next case, Emily Spanton. Emily is a little special because although she's from Toronto and the basis of her claims are similar to Mandi's, her case takes place in Paris, France. What makes this so palatable is that we get to see how differently the French legal system handled the case in comparison to Canada. The basis of Emily's claim was that she went to a bar in Paris, a pub, and joined a group of about 10 off-duty police officers partaking in a Tequila Tuesday party that the pub holds. She became extremely intoxicated, and they invited her back to the police station for a tour. Next thing she knew, she was being gang raped by at least 2 French police officers in the Paris police headquarters. She claimed that she was too drunk to give consent to sex and didn't know what was going on, and that the officers abused their authority. The basis of the defense's claim was that they had consensual sex. I don't have any other details other than what the Toronto Star's Wendy Gillis explains fairly thoroughly in this article. There was a text message between 2 of the officers that implies she was into having sex with multiple men that night. The text read, "Hurry up, she is a partouzeuse." Pardon my French. The French judiciary ultimately declined to prosecute on the basis of insufficient evidence. So now the officers will need to get back to repairing their lives and reputations after the 2-year ordeal of suspicion and investigation procedures. Now, the common complaint between these 2 women accusers was that they both had to endure an invasive investigation. But here's the big difference between those investigations. In Mandi's case, whenever the defense attorney or a police officer tried to have her investigated or ask her probing questions to reveal any credibility issues, Mandi and her lawyer were able to deflect it with a law or a precedent that prevented the defense or the police from doing so. In Emily's case, the French judiciary mandated that she be investigated, including being interviewed by a psychologist and having her friends and family interviewed specifically to determine if she would be a credible witness. It turns out that the French psychological review concluded that she has a tendency to over-dramatize, and that because of her personality and level of alcohol, that psychologist had strong reservations about relying only on her testimony as an accurate account. What's equally eye-opening is that Emily had a Toronto-based psychologist assess her as well, and that was a vastly different conclusion of suffering from post-traumatic stress disorder, but that she had given a reliable description of the facts. If you have watched any of my videos from my series, Evolution of Feminist Theory, Moral Panic, and the Law, you'll know why this is so alarming, particularly parts 3 and 4. Go watch them after this if you haven't already. The French legal system obviously took this case very seriously to ensure that the only issue of credibility was thoroughly vetted for both sides of the complaint before further wasting resources on a trial. French officials were even flown to Toronto for the investigation into her credibility. Now, it could possibly have been a different outcome if the accused men weren't police officers. However, given the Napoleonic or the inquisitorial structure of France's legal system, I doubt that it would be much different. Bravo, Paris, France! So, to sum up the vastly different procedures of law in cases of she said, he said rape claims, where consent and credibility is the issue, we can see that the Canadian legal system is already tilted heavily in the direction of protecting women who may not be a credible witness, by blocking their credibility from being probed at all points during the police investigation phase and even at trial. This cripples the defense from being able to build a case. Meanwhile, in France, the opposite is true. The credibility of both the accused and the accuser must be investigated and determined before ever going to trial. Now that to me sounds like due process and equality under the law. So, to you, Emily Spanton, I will say, suck it up and good luck trying to change the apparently fair French legal system if that's what your crusade will become as a result of your rejection. And to you, Mandi Gray, I say, congratulations! Your case has helped to showcase every law and precedent that needs to be repealed, reversed, or overturned within the Canadian system in order to return safeguards to protect the innocent accused from being unjustly prosecuted and convicted. Or to put it in more dramatic and frank terms, to protect men from being kidnapped by state-sponsored men and women with guns, interrogated, held captive against their will, and held for ransom, because nothing happens in his favor till he pays someone money. All at the whim of a whiny feminist whose feelings might have been violated. And lastly, to you, Mustafa Ururyar, you have 3 months before your sentencing hearing to find a damned good appeal lawyer who believes in fighting the discriminatory laws and precedents that convicted you. I believe you have a chance, albeit a small one, given Canada's current political climate. Until then, you might be subjected to psychiatric assessment for deviant sexual behavior to inform your sentencing. That often result in poorly interpreted results that will stay with you and your mental health record for the rest of your life. I wish you, Mr. Ururyar, the best of luck.